It started a decade ago as part of a national effort to redress the suffering of Indigenous people who had been subjected to egregious abuse in residential schools. It's called the Independent Assessment Process. It's collected a vast body of evidence and testimony from thousands of people as part of the claims process. The fate of those records has since become a matter for the Supreme Court. And to help us understand why, we're joined on the line from Regina, Saskatchewan by Dan Shapiro. He is Chief Adjudicator for the Independent Assessment Process. Dan Shapiro, it's good to have you on TVO tonight. How are you doing?
I am well. Thank you for having me on your show.
It's a pleasure because we definitely need and want to know more about this. And I'm going to start just by putting a few facts on the record here, and then we'll chat right after that. Sheldon, bring this graphic up. Thank you. The Independent Assessment Process was created in 2007 to resolve claims of serious abuse suffered by former residential school students out of court. Now, 98% of the 38,000 claims have been resolved, 98%. More than 3,000 claims came from the province of Ontario. They had initially expected only 12,500 claims overall. They have conducted more than 26,000 hearings, and 89% of claimants got compensation. The Government of Canada to date has paid out more than $3 billion to resolve these claims. The average compensation was more than $90,000, and they expect the whole process to be finished by the spring of 2020. Okay, with that background, Mr. Shapiro, in place, tell us how your work differs from the work done by the Truth and Reconciliation Commission, which I suspect many people know of much better than your organization.
The Truth and Reconciliation Commission was always the public face of the settlement agreement, the Indian Residential School Settlement Agreement. And our role was to deal with the private, sensitive, confidential reparations process within the settlement agreement, known as the Independent Assessment Process.
For those who are not as well aware of this story as perhaps we might ought to be, can you give us a sense of the kinds of testimony that you were hearing from those who went through the whole residential school system?
We heard testimony on everything from physical and sexual abuses to verbal and emotional abuses, and on top of that, on the impacts that these abuses had on people's lives. And so they are really among the most personal and sensitive records you can ever imagine being generated about a person.
And we indicated a moment ago that you've done more than 25,000 hearings. Where, for example, have those hearings been held?
The independent assessment process is a claimant-centered process, and so we strive to do whatever we can to put the former student at ease. And we've given the claimant the choice of hearing location, and as a result, have held hearings in people's homes, in hearing rooms, in hotel meeting rooms, in hospitals, nursing care homes, and correctional facilities.
So wherever it's most comfortable for the claimant?
Yes, and unlike the courts, we go to the claimant. We don't expect the claimants to come to us.
And give us a sense as well as to, I mean, obviously the claimant is there, there's an adjudicator there. Who else is involved?
In addition to the claimant and the adjudicator, there is always a representative for the Government of Canada in attendance. In addition, there can be representatives from the church. There can also be health support workers, Indigenous health support workers, there to support the claimants. There can be elders. And at the claimant's discretion, there can be family members. Interestingly, in very many of the cases, the claimants would ask their family members to leave the hearing room when they got to the more sensitive parts of their testimony.
In the more than 25,000 hearings that you've held, has there ever been a case where somebody actually wanted one of the perpetrators in the room as if to sort of look them in the eye and, you know, have that moment?
Well, there have been situations where former students have indeed wanted to confront the alleged perpetrator, and in fact the other way around as well. Now, the claimants are entitled to be, if the alleged perpetrator chooses to have a hearing, the claimant is entitled to be at that hearing. On the other hand, if the alleged perpetrator chooses to participate in the process, They are not entitled to be at the claimant's hearing.
It's up to the claimant to decide whether they want their perpetrator there.
Well, even, they can request that, but they have no ability to compel an alleged perpetrator to be there. The process is voluntary, and that's on the part of all participants, former students and alleged perpetrators alike.
Understood. Now, you've told us it's not, these hearings don't take place in a courtroom, but given all of the players who are at the table, I do wonder how adversarial the tone of the hearings are. Can you help us on that?
Well, we have striven to achieve a claimant-centered process. That doesn't mean the claimant will succeed with an award in each case, but the intention is that in each case, the claimant leaves the hearing room feeling heard and respected. And that is certainly one of the pillars of our process. The other aspect of it is we are unique among tribunals in that we are an inquisitorial process. And what that means is that the adjudicator, rather than the lawyers for the parties, leads the questioning. And so if there are areas that are contentious, those can be raised by the parties, but in the absence of the claimant, there can be caucus discussions where the parties can ask the adjudicator to follow up with certain lines of questioning. But a large part of the adversarial process is removed from our process because of the adjudicator leading the questioning.
Okay, Chief Adjudicator, I need to ask you about the whole issue of privacy, because of course the Supreme Court has weighed in on this issue and has guaranteed privacy rights to those who are participating, which I guess in essence means that if they don't want their very personal, private stories to exist in an archive for time immemorial, they have the option of not having that happen. How concerned are the claimants that you have had dealings with in terms of ensuring that their stories stay private if they want them to be?
Before I became Chief Adjudicator, I've been doing hearings involving Indian residential school abuse claims since 2003. And I can tell you from my own experience, as well as that of other adjudicators, that the issue of privacy and confidentiality is often the single biggest factor that will allow people to come forward and share their experiences. And we have been told often by claimants that they would not attend a hearing or would leave a hearing unless they were satisfied that their experience would be kept confidential and private. And in many cases, the hearing is the first time, and in some cases claimants tell us it's the one and only time they ever intend to speak about what happened to them in residential school. But often it is the first time, and they have not spoken to their family members about it and wish to keep it that way. And so we have had people that have shown up for hearings in states of very high anxiety, including such presentations as panic attacks, vomiting, stories of insomnia the preceding nights, or a return to substance abuse, all involving facing their hearing and worrying about the possibility of their experiences being shared within their families or within their communities. So it is a huge issue, and without those assurances of privacy, I believe that very few of those experiences would have been told.
So I take it a big part of your job is just ensuring or convincing those who participate that, yes, if you don't want your story out, it's not going anywhere. Have I got that right?
Well, it's not just assuring and convincing, but this is part of the settlement agreement, and there were, in addition to the promises of confidentiality in the settlement agreement, at each and every hearing, all of the parties, including Canada, which later argued in the courts that it didn't really have the legal effect that most people thought it did, signed confidentiality agreements. So the adjudicator, government lawyer, claimant lawyer, church representative, health support worker, all signed confidentiality agreements, and that was the very first thing done in each hearing, and designed to set people at ease that they could share their experiences fully, which they needed to do in order to access a compensation under the agreement without being worried about their experiences being shared.
Okay, at the risk of getting too literal here, I mean, a hearing takes place, presumably notes are taken, there is a record made of the testimony and the results of the process. What happens to that record if a claimant decides they want the record expunged? How do they actually do that?
Well, at this point, the Supreme Court has upheld the lower court decisions which have decided that claimants don't need to do anything. If they don't want their records shared, they don't need to do anything. The records will be kept for 15 years from the end of their claim to give people a full opportunity to consider or reconsider their decision, and then they will be destroyed. If, on the other hand, people want their transcript, for example, a transcript of their hearing, all they have to do is request it, and it is provided to them. And that is a right that has always been available to claimants, and we have always made a point of letting them know about that. When they get the transcript, their own information is included, but information that could identify others, including alleged perpetrators, is edited or redacted.
And what would be the reason for making them wait 15 years before having the option of having the record destroyed or destroyed from the archive?
Well, it wouldn't go into the archive unless they had consented to doing that. However, we will keep the records, and that is the order the court would make, the court has made. The 15-year period was not something that I recall any of the parties advocating for. This was a period that the first court who heard the case, the judge of the first court that heard the case, decided on, and it was upheld by the later courts. And I believe the reasoning behind it was just so that, you know, people may, as of today's date or soon after their hearing, not be willing to share their experiences. However, on reflection, they would have the ability to do that after a lengthy period of reflection. So one of the options the court didn't give was the ability to request that the records be destroyed immediately. So they are kept safely and securely with our Secretariat, and they are not available to anyone without the written permission of the former student.
I know this is an area of controversy, and you as the chief adjudicator, I don't have to get into this with you. We're going to discuss it later in the program. But I guess it points to, you know, the ultimate question at the end of the day, which is, whose stories are these? To whom do they belong? The victims themselves, or in some respects, to the process, to history? I'm sure you've thought about that. Where do you come down on that question?
We have always taken the position that the settlement agreement puts the stories and what happens to them in the hands of the claimants to decide on. So that means it's not the Secretariat or the chief adjudicator that decides, it's not Canada that decides, it's not the National Centre for Truth and Reconciliation that decides, it's the claimant that needs to make those decisions. Interestingly, many of the same people that have testified in the independent assessment process have also chosen to provide voluntary statements and testimonies to the Truth and Reconciliation Commission. And all of those records, along with millions of other records provided by government and churches, have now been deposited with the National Centre for Truth and Reconciliation. And there is really no danger whatsoever of the history of residential schools being forgotten, and that is due in very large part to the phenomenal work done by the Truth and Reconciliation Commission, having gathered these millions of records and having ensured that the residential school experience is etched in the public consciousness. But it was a very different process. It was a voluntary process and a public process for the TRC. And to suggest that people should have their private confidential stories that were given for a very different reason and a very different context, that of pursuing compensation, to suggest that those should be forced into an archive would, in my view, amount to a very serious betrayal in a process that is, after all, designed to rectify a very significant historic betrayal in the first place of setting up the schools. So I'm very pleased that the Supreme Court of Canada, in a unanimous decision, upheld the promises of confidentiality made in the settlement agreement and decided that there was no right for anyone else to conscript the claimant's experiences for the purposes of public education or otherwise.
Okay, in our last minute here, I need you to help me understand one last thing, and that is when we went through the numbers at the very beginning, we indicated that 98% of claims have already been resolved, and yet I still see that it's another 2.5 years before you expect that last couple of percent to be dealt with. How come so much time still for so few claims?
Well, the last claims that are with us, we have committed to making sure that people would be entitled to the same fair and claimant-centered process that folks had at the beginning of the process. The reality, however, is that of these claims, many of them involve people that are lost in the process, and we have put through an exceptionally robust process to track people down, which, as far as I know, is not being used in any other tribunal. And so we are trying to track down these lost claimants. We have found many of them. A number of the claimants have passed away, or there are legal complexities in the last cases, including the fact that many of the claimants do not have lawyers and are representing themselves. So the last claims are taking quite a bit of time, and we need to make sure that they are done right and to give people the opportunity they need to put their case forward, if they can, in the very best way that they can.
Dan Shapiro, Chief Adjudicator for the Independent Assessment Process. I think we know this story way better now, thanks to the time you spent with us on TVO tonight. Thanks so much.
You're welcome.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.